Appeals Division 1 is now in session.
Please be seated. We're here in 1CA-CV22-0469, Paris Steel versus William Powers et al. Each side will have 20 minutes to present your argument. Apparently, you may save as much time as you want for rebuttal, but you'll have to keep track of the time yourself. We have a clock at the podium for that purpose. We are recording the argument both in audio and video, and it will show up on YouTube in a day or two, so you can watch how well you did. Because we're doing that, though, please identify yourself and your client when you begin your argument so that we can keep everything straight. We've conferenced the case, we've read the briefs, we've looked at the record, we're familiar with the facts of the law, so when you begin your argument, just go right to what you would like to talk with us about. Counsel, you may begin.
May it please the court. My name is Eric Schmidt. I'm here on behalf of Appellant Power Steel and Wire Products Incorporated. With me is my colleague William Quinlan, and also present is Mr. David Agizi on behalf of Power Steel. Your Honors, there's two halves to this appeal. One half dealing with issues concerning Suncoast and John Walsh, the other half concerning issues with William Powers and Powers Reinforcing Fabricators. I'm going to take the Suncoast and Walsh issues first and then go into the William Powers issue. So on the Walsh and Suncoast side, the central dispute here really concerns damages and the definition of damages. Suncoast argues that Power Steel's damages for both under the Uniform Trade Secrets Act and for breach of fiduciary duty are limited to its own lost profits.
Okay, so I'm concerned about that issue because I wonder what the lost profits are. There were jobs that your client was going to do and had bid on them, but they all got canceled because of Mrs. Powers' decision to do that. So those profits went away, and I understand that Suncoast picked those projects up, but they were doing it for the same price, and I don't see why Suncoast couldn't have done those jobs when your client's company affirmatively gave those things up.
So a few issues, Your Honor. One, we do not concede that Power Steel gave up at least the Toscana job. We believe that there is an issue of fact on that with respect to Janet Powers' testimony. But two, I don't believe it's accurate, Your Honor, to say that Power Steel gave up the jobs, or they did not, I should clarify, they did not give them to Suncoast. Even if it is true that Power Steel...
What is it their business who it goes to? I mean, if they're saying we're rejecting a job, what difference does it make whether it was Suncoast or another competitor who picked it up as far as their damages are concerned?
Sure. And this is what I want to draw the distinction between Power Steel lost profits as damages and Suncoast unjust enrichment. And under both the Uniform Trade Secrets Act is explicit that you can get both. You can get either, we use the word both, your lost profits or the unjust enrichment from the misappropriation.
But on this fact issue that the judge looked over, as to unjust enrichment, isn't there a justification factor that there has to be an absence of justification in their enrichment if you find all the other factors? And help me understand why we wouldn't accept that Power Steel saying that they weren't going to go forward with these bids is not justification for someone else, Suncoast or someone else, profiting as a result.
So I'll address the trade secrets issue first, because I think that's the most straightforward. The trade secrets is simply if you use someone else's trade secrets, you're entitled, without their permission, you're entitled to the profits they earn, the unjust enrichment they earn. That's both the Trade Secret Act and the Gore case actually has a nice quote on that at the W.L. Gore case.
Right.
It says that for purposes of summary judgment, the only question is whether plaintiff, GID, has presented evidence from which a jury could determine that defendant Gore profited or GID was damaged by the misappropriation.
But don't they also have to, under Gore, find that misappropriation of the trade secret was the proximate cause of those damages? And if, wouldn't summary judgment be valid if you can't make that proof?
So proximate, excellent point, Your Honor, but it's proximate cause of either the damages to the plaintiff or the unjust enrichment. And here, there's more than sufficient evidence to find that the use of Power Steel's trade secrets benefited Suncoast. I think that you just look at the testimony of Mr. Walsh himself.
But are we kind of going in a vicious cycle of saying we have damages because there's unjust enrichment, but there may have been justification, but then we go back to trade secret and say, yes, but you get damages just for having the trade secret, but that hinges on whether you have proximate cause that it caused the damages. I mean, I'm hearing, and maybe help me understand why I'm wrong about this, but it feels like we're kind of spiraling around the same issues, which goes back to the concession of saying we aren't going to bid these projects that aren't under contract yet. And so why do we care about who profited from them once you guys cast them aside?
Because this Trade Secret Act is clear that you cannot use someone's trade secrets for your own benefit.
Well, but the testimony was from Bill Powers and John Walsh, and I don't believe it was contradicted, was that this is done all the time, that if for whatever reason you can't complete a bid, you can give the bid information to someone else and who can complete the bid. So there was testimony from two people on that, and I'm not aware of any testimony that, oh no, we never ever do that.
Your Honor, that's an excellent point, but I'd like to make a distinction when people refer to bids, referring to solicitation documents that they receive versus their own internal bid preparation documents, we'll call them, which in this case we say included the estimate reports, the pricing sheets, and the shop drawings. And there was testimony from Mr. Walsh himself that he had never before this instance ever shared pricing sheets or shop drawings or estimate reports with a competitor. There's also the affidavit of Paul Curry, a Power Steel employee that's included in the reply appendix, where he said Power Steel did not ever share an estimate report. It did not ever, as a matter of policy, did not ever share its estimate reports, did not ever share its pricing sheets, and did not ever share its shop drawings.
But then we come back to the question that Judge Bailey and I have been discussing with you, even assuming that that information shouldn't, or that information was a trade secret. If there were no financial damages to the disclosure of the information, then you can't make your claims. The summary judgment will be appropriate.
So I think we need to draw a distinction between the existence of damages and harm to Power Steel and the existence of quantifiable damages. And this is why the Trade Secrets Act, and this is why the restatement and others that talk about fiduciary duty allow for unjust enrichment. I think even if Power Steel is not performing a job, there's still harm to it by the disclosure of its trade secret or by John Walsh helping a competitor get a job. Kind of walk through. I mean, it's, you can imagine all sorts of reasons why you wouldn't want a competitor to get a job, especially, go ahead, Your Honor.
So So if I can't do the job, I don't want anybody to do the job. That's kind of what it sounds like to me.
Well, it's a little different. It's you don't want them to do it with your bid preparation documents. Documents which it's undisputed are the result of significant skill by Power Steel's estimators and detailers, and which would save Suncoast time in achieving a job. And I think it's also...
Do we have the Sugarrath report in full somewhere in the record? Because our discussion was we see pieces of it, redacted pieces of it throughout, but do we have, is there a record site for having his report in full that you
My
could...
recollection, Your Honor, is that it's under seal attached to one of something in the summary judgment. I don't have that offhand.
Okay.
My recollection is it's under seal.
Under seal in the Superior Court, or it made its way over here under seal?
It was filed under seal in the Superior Court, so hopefully it made its way up here. But
Okay, all right, fair enough. Do you want to talk about if we say, all right, we're two trade secrets and we're on to damages, and the court errantly found that this report was the basis of saying that there were no damages. Tell us about why what should have been standard isn't speculative in the way that your expert crafted what the damages were. It seems like, and again, disabuse me of this, that the basis was that both Walsh and a number of other employees were basically going to be at Power Steel for an indeterminate amount of time. And in light of what I think your side concedes in the Superior Court, Janet wanted that division shrunken. I mean, I think it's undisputed that the smaller projects of $300,000 or less, that the fat was going to have to be cut, that people were being fired. So this idea that was happening on the one hand, but on the other hand, you have an expert who's saying, look, this unit should have gone on undisturbed indefinitely, and that's the basis for our damages. Help me understand why that's not speculative.
Sure, Your Honor. And I would just like to emphasize that the standard of review right now, it's summary judgment.
De novo. Absolutely.
And I would say the Schweikerath report was intended to set the quantity of damages, but there's plenty of other evidence in the record as to causation, or which, when viewed in the light most favorable to Power Steel, causation of damages could be inferred.
But is the court required to go through and ferret out the causation? Isn't that part of the responsibility of a damages expert, is to show the proximate cause of these damages? I mean, anybody can just, I assume that everything my client says is exactly right, I don't need to look into any of it, but if all that's true, here are your damages, without any other basis in fact that your expert was relying on for cause?
So, Your Honor, I guess my response would be that there's no requirement that you have an expert to prove causation. All it is you have to offer evidence. And I would say here, in terms of the employees, when looked in the light most favorable to Power Steel, we have 3 employees that were recruited, literally made job offers by John Walsh while he was employed at Power Steel. And we have the evidence by Suncoast's own admission. Prior to this, they had 1 employee in the rebar division. Afterwards, they had 5. That, when inferred in the light most favorable to Power Steel, it can be inferred pretty easily that some portion of that growth was the result of these new employees. Now, just for the purpose of summary judgment, Power Steel was not required to prove with exact certitude that it all was, and some portion may have been caused by other things, but that's for trial. That's something trier of fact will determine.
Even at a summary judgment stage in Superior Court, it's for trial that you're going to weave it all together and show what your real damages are? That's a little bit confusing to me. We're just going to throw out that there's some damage, it's kind of amorphous over here, but once we get to trial, we're going to have that good number because we're going to pull it all together.
So a few things, Your Honor. One, I don't think there is this kind of amorphous issue with respect to the trade secrets, right? I think we laid out, we know that there's very good evidence that these trade secrets were used for the jobs. We know the value of them. We know approximately what the profit margin would have been. That's about as good as you can get in an unjust enrichment claim. With respect to the employees, Power Steel is not claiming that there was some amorphous number. It's claiming that the growth was due to this. And we have, I think, pretty venerable precedent. There's a learned hand case in there that when there's a range of uncertainty in an unjust enrichment setting, if the plaintiff's entitled to the high end, the defendant can certainly make his or her arguments as to why it should be lowered. But if they don't do so, then the plaintiff's entitled to the high end of that range.
There was no employment agreement with the three employees, that they were at will, correct?
That is true.
So that means that your client could have fired them at any time with no financial consequences for that.
If they had chosen to fire them, yes, Your Honor. But
So if you're an at-will employee and you get a better offer, fine, I'm going to take that better offer.
that may be true, Your Honor, but in this case, Power Steel had the right to the loyal duty of its employee, its high-level employee, John Walsh. And John Walsh literally, this is not a question of just whether he encouraged them to leave. He literally solicited these employees, and that's a clear violation of his breach of his fiduciary duty.
I want to go back to the unjust enrichment, and I'm going to give you a hypothetical, and I'm interested to hear your answer. How would the situation have been different if rather than, the documents that you argue were trade secrets that were passed, your company just dissolved the rebar division, employees were let go, they went to other companies? How would the situation be different there where, Sunco would be able to grow their business based on, the lack of Power Steel being in business anymore? How would this be different?
Is the question with respect to the trade secrets or the employees, Your Honor?
I'm looking at unjust enrichment.
Okay. With respect to the trade secrets, so long as Power Steel so long as those were trade secrets, Power Steel would have been unjust for Suncoast to have used them. It would be unjust enrichment. With respect to the employees at Power Steel.
But what I'm saying is if we're taking the trade secrets out of it.
Okay, yes, sir.
Okay? Sunco now takes all the business from Power Steel because Power Steel isn't doing that business anymore. They grow their business. How is the situation where these documents were used, if we take your argument, right, and we give, everything your argument that this unjustly enrichment, I want to know how it's different with these documents going back and forth than if Power Steel had just done away with their stuff and said, we're not in this business anymore, and Sunco still grew their business based on that.
Sure. If the documents were taken and used after Power Steel did that?
No.
I'm sorry.
I'm not, no documents were used. I'm just saying, Sunco has the ability to grow their business based on Power Steel not doing it anymore. What I'm trying to get at is you're arguing it that Sunco was unjustly enriched by these trade secrets that were passed back and forth. I'm trying to understand what the difference is if those documents hadn't been passed back and forth and Sunco still grew their business. How is that different?
I mean, if Suncoast just used normal competitive means, they're entitled to grow their business, but that's not what the evidence shows here. The evidence shows that they benefited both from the use of Power Steel's trade secrets and the Walsh's breach of his own fiduciary duties that he owed towards Power Steel. And Your Honors, at that, I'm at 3:30. I'd like to reserve the rest of my time.
Thank you, counsel. Counsel?
Good morning, Your Honors. May it please the Court. My name is Lauren Molliver, and I represent Powers Reinforcing Fabricators and William, or Bill Powers. And this is limited to the issue of the sanctions that were awarded by the Court in favor of my client against the plaintiff. I want to start off by saying what this issue is not. It is not for conduct of Power Steel in the related Vinton case where they sued my client's supplier. It is for conduct that also occurred in Vinton, and it occurred in our case too, because the Power Steel didn't change its stripes. This is not sanctions for failure to settle the case. No party is required to settle a case. This is a sanction for conduct that unreasonably expanded and delayed these proceedings under the statute. The motion for summary judgment in Vinton was, as the court noted, a benchmark, a timing benchmark, the latest time in which Power Steel should have recognized that they didn't have proof of their claim at all. And I'll get to the Schwickerath report as it relates to that too. But I want to just spend the limited time that I have, because there's two of us, dealing with the conduct that is in the record that supports the sanctions that hopefully the court will recognize, and as the law says, you'll defer to the trial judge on that issue because it's supported in the record. Number one, while Power Steel was trying to enjoin my client and put them out of business back in 2018, they sent these 3 letters to our business associates asserting that we had in fact breached a fiduciary duty. Number 2, they indicate that they didn't do anything wrong with the disclosure of witness Gary Whipple, one of their employees, because they disclosed who he was. What they didn't disclose was that he was instructed to prepare a wind-down memo to stop the rebar business for Power Steel, and we had to get that after inadvertently, if you will, fortuitously discovering it in Mr. Whipple's deposition. And that's related to another discovery problem. It wasn't until February of 2020, despite ongoing disclosures from Power Steel, where they continued to maintain they were in the rebar business, albeit at a reduced level, that we found out that they were not only not in the rebar fabrication business anymore, but hadn't been for about a year. And we found that out through some late depositions of 2 of their employees. They had maintained, even as of the date of one of those 2 depositions in February of 2020, when they submitted a supplemental disclosure, it still was telling us that they were still in the rebar business. Why is that important? Because they were claiming that we were unfairly competing with them when they weren't even in the business and hadn't been for quite a long time. Next is witness Dan Wiggins. Janet Powers testified early on. They hired Dan Wiggins to investigate the alleged wrongdoing of my client, Bill Powers, when in reality, the bank required them to hire Dan Wiggins because they were out of compliance with their loan documents. We found that out later. It was wrong for them to mislead us as to why he was involved, what he was doing, and how he was doing it. Power Steel refused to disclose after alleging that we had stolen its business. They refused to disclose the bids that they purportedly lost to our client all along, and instead maintained that we had to provide them all of our financial records, despite that they hadn't disclosed any of that. And in June of 2019, Judge Contis, who was then on the case, ruled in favor of Powers reinforcing and said, we don't have to give them the financials, and they're not entitled to the they're not entitled to our financials, and we are entitled to their bids, which we ultimately got. And there's a wrinkle to this very issue that's significantly important, because after Judge Contis ruled they can't have our financials, they subpoenaed them in the Vinton case, and we had to intervene in that case, and the court agreed with us, calling it an end run around Judge Contis. It's rare in my experience where judges do what multiple judges did in this case, and that is to state on the record things like Power Steel was involved in a vendetta against Bill Powers, Power Steel intended to harm Powers Reinforcing and Bill Powers, they had a motive to put them out of business, and all of this is in the record, and it supports the fact that the conduct that I'm talking about unreasonably expanded and delayed these proceedings and more than justifies sanctions that were only 15% of the fees that my client incurred. It's not as if the judge went wild and decided, I'm going to give them everything. He only ordered 15%. Let's talk about the Schwickerath for just a minute. His reports in both cases were, as the court stated, not me, cookie cutters, but for the total damages that they were seeking. As we know, and as Judge Bailey acknowledged, at least I am interpreting your acknowledgement, and the record says this, Power Steel said, assume all the facts, assume causation, and just tell us how much money we're entitled to as a result. And that's based upon Bill Powers also working for Power Steel for the rest of his life and never being able to do anything else. The court bashed the Schwickerath report, and it required us to hire a CPA and spend a ton of money trying to establish essentially a negative, that there was nothing in the report that could support the claims that Power Steel was making. I want to talk about the law for a minute, because I've been harping on this for years. Maybe your honors will tell me that I'm wrong about it. It is appropriate for a lawyer to argue one side of an issue, and in another case, argue the other side if it's done ethically and if it's done appropriately. What's not okay is for, in this case, the controlling case in Arizona on whether Bill had a fiduciary duty to Power Steel after leaving is MIMS. They never cited MIMS until we brought it to the court's attention, and then they argued repeatedly throughout this case that MIMS stands for the proposition that Bill did have a fiduciary duty to Power Steel even though he only owned non-voting 16.7% of the shares. When in reality, MIMS says if you are a controlling shareholder, in that case a 50% shareholder who controlled by veto power, then you may be having a fiduciary duty to the corporation. And Power Steel's counsel was counsel in MIMS. So there's no excuse for Power Steel to continue to offer in this case that MIMS is supportive of their position, requiring us repeatedly to have to demonstrate why it's not. Same thing is true with the V.J. Doyle case on the use of the name Powers. They never cited that case until we brought it to the court's attention, and that case says you can use the same name so long as there's no intent to deceive, and in this case, of course, there was no such evidence. And that's why the court granted summary judgment in favor of Powers Reinforcing and Bill Powers on every claim that Power Steel made. In conclusion, so I can give time to my co-counsel, the statute, section 12-350, requires the court before awarding sanctions to consider the factors in 350. And the court did, and the court said it did, and the record reflects that it did. Power Steel would have the court rule against sanctions because the judge didn't enumerate all of the factors in his order, but there's no requirement that the court did that or was supposed to do that. We cited two cases in conclusion that say the following: sanctions are within the discretion of the trial court and are not to be disturbed but for an abuse of discretion. And number two, if sanctions are supported by the record, this court will not say that the trial court clearly erred. Thank you very much.
Thank you, counsel.
Good morning. I'm Caroline Larson with the law firm of Thorpe Schwer. I represent the appellees who were the defendants in the trial court matter: Suncoast Post-Tension Limited, John Walsh, Russell Price, Larry Stadler, and Perry MacArthur. Throughout, I refer to them in briefing as the Suncoast defendants collectively. If the court undertakes a de novo review, you should still uphold the trial court's well-reasoned entry of summary judgment in favor of the Suncoast defendants. This court has an incredibly extensive record before it, I recognize that, but nowhere in there, despite raising so many issues and so many purported factual disputes, has Power Steel presented any evidence that there was a material dispute of any relevant fact that warrants overturning summary judgment. Due to time, I'm sorry?
Counsel, your colleague says that there is a dispute over whether it was kosher for Bill or John Walsh to supply the detailing information or the estimating information. Is that accurate?
Your Honor, I don't think I would attempt to defend that Power Steel appropriately objected to the disclosure of certain information, particularly information that wasn't related to, for example, the Toscana job. They focus on that extensively, but I think the record is clear on 2 points. A, that Janet or nobody else at Power Steel was able to refute John Walsh's testimony that job had been bid by Power Steel, and that to the extent that the client had indicated an intent to use them, there was no contract. Janet made it clear that she was canceling that. And the information that he shared was not to try to compete against Power Steel unfairly, not to misappropriate their information, but literally to ask Suncoast, here is the bid, here are the details, can you possibly perform it at the same rate?
And why wasn't that a question that the jury should get to, a factual question? I mean, you say, and I think the minute entry relates that the court, well, the other side says that the court wrongly discounted Janet's testimony about whether she believed they had the case. Why shouldn't the same be credited to John Walsh's testimony about why and what he did? Why isn't that an issue that should have gone to the jury, just that singular issue?
Because Ms. Powers' testimony is not clear at all.
Well, it may not be clear, but she certainly makes statements that affirm the position of appellant. And while I see that there are other statements that were inconsistent, again, is that for the trial court to discern who's credible, who's not, that inconsistent statements merely mean that she shouldn't be credited any of her testimony regarding this issue, or is that something that should have been passed on to the jury as a fact issue?
No, the appellant has to raise a material issue of fact, and the trial court appropriately found that Ms. Powers' statements were inconclusive, that they provided they were self-serving. She attempted to kind of clean it up after the fact, but she was deposed.
Was Mr. Walsh's self-serving though as well? I mean, isn't anyone who's defending themselves against a lawsuit, their statements could be labeled self-serving and therefore immediately discountable and a jury shouldn't hear them?
I think that based on their premise that the work was awarded and then somehow inappropriately misdirected to Suncoast, they are required to provide some evidence of that. There was no contract, there was no award, and her statement was, I think we had that, maybe we had that. She couldn't recall which job specifically she had directed Mr. Walsh to cancel. They tried to claim that it was several jobs, a handful of bids. However, the email that Mr. Walsh sent went to numerous clients saying any job that's been bid that hasn't been contracted will not be upheld at the price that was bid. And so that sort of backs into, what most of opposing counsel focused on in his argument, which is that I wanted to draw the court's attention to. We touch on it in our brief, in our answering brief at pages 9 and 10 and at 31. But if that is the approach that Power Steel had taken throughout the case, is that there are a handful of jobs. We argue, we Power Steel argue that we intended to perform these jobs, that we had bid these jobs, and if awarded, we would perform them. Suncoast was able to take those jobs. We believe, without evidence, that they used our confidential information to secure those bids, and we're entitled to, our measure of damages is profits on those handful of jobs. It's inconceivable that we would still be here 5 years later beating this case into the ground. That was not the approach that they took throughout. The case was filed in February of 2018. Throughout April and May, subject to the court's order on the preliminary injunction hearing, Suncoast had returned all of the documents that Mr. Walsh had shared back to Power Steel. Suncoast also disclosed a list of all the jobs that it bid after Mr. Walsh came to work there, and all of the jobs that it had been awarded and the contract price. So at all times, Power Steel had the evidence at its disposal, if that was the theory of damages they wanted to pursue, to do that. They made no disclosure until they produced Mr. Schwickerath's report. The court noted in its summary judgment order that's EIR 737 at page 26, and we discuss it in our brief. The court very much focused on the fact that the entire measure of damages that Power Steel presented was the Schwickerath report. The Schwickerath report does not discuss the Toscana job. It doesn't discuss profits or profit margins on particular jobs. It makes the argument that Power Steel has made throughout this case that the entire decline in its business and the entire increase in Suncoast business is the measure of their damages, and that increase in business is the result of the conduct that they allege in the complaint and throughout the action. It is only at summary judgment that they try to now backdoor this different theory that, that there was some testimony about profit margins, that despite, Janet's testimony that she...
But you were on notice because it was summary judgment. So whatever argument they brought up at summary judgment, just because it hadn't been made before, you were on notice of it. There's no Rule 56 that you needed more information because they've taken a left turn that you didn't anticipate. I mean, people can change course. That's not your argument, right?
It's not, absolutely not, Your Honor. I mean, anything that's disclosed is fair game at summary judgment and here as we sit on the appeal. However, the issue that led to summary judgment, I think, is these gaps, is the fact that that wasn't what they proffered before. They had relied entirely on this increase-decrease argument, which they're still sort of spinning in their briefs. And that there wasn't an appropriate record to tie them to these, this handful of particular jobs. But even if we went that course, even if we give them all inferences because it's summary judgment and de novo, that these were the handful of jobs, they presented absolutely no evidence to contradict the showing by Suncoast that it fairly bid these jobs, that it didn't use any of their information they presented. They had years in discovery to show, did you underbid us, for example? Do you use something in our estimates or our pricing to unfairly compete? They don't, at this point, get to just make broad inferences. We're not at the Rule 12 stage. They had years of discovery.
Turn your corner just a little bit before we lose you. As to the kind of the Pope analysis that the court did regarding the employee Robinson and those facts, kind of the same question I have about, did the court overstep by crediting John Walsh's testimony over Robinson's testimony and later his disclaiming in his deposition of the affidavit that Suncoast had prepared for him regarding the circumstances of his, I mean, that seemed like the closest call. And I'm just wondering if you can justify kind of that Pope analysis that the court did, why a jury shouldn't have had a chance to weigh the Robinson factors.
Again, and I, in fact, in preparing for this, went back and looked at the specific testimony they cite. And Mr. Robinson is very unclear about timelines, about what his plans were. Mr. Walsh was the one who said, when Mr. Robinson told me he was going to leave, I said I was leaving and perhaps there would be an opportunity for him there. Mr. Robinson testified he didn't recall that. So when you have the witness himself saying, I don't recall being solicited, I don't think that you can argue that there is an issue to take to the jury. And importantly, again, when you come back to the Schwickerath report, he pins everything on the departure of a couple of at-will employees. Even if, again, giving all reasonable inferences, we argue Mr. Robinson or any of these other three employees, Mr. Doshi or Janet, were improperly solicited, that they wouldn't have gone to Suncoast, that it was a breach of Mr. Walsh's duties. Power Steel offered absolutely nothing in either a damages theory or causation. They offered no evidence of a single job that they were unable to bid or unable to perform as a result of the departure of any of these employees. Replacement employee costs. They just, they basically have offered only Mr. Schwickerath's report, which says, everything we lost is simply because you hired four-will employees, disregarding the fact that upon hiring someone like Mr. Walsh or anyone else simply to grow the rebar division, that of course it would naturally increase in business.
Counsel, so if I am to understand your earlier comment, you agree that the papers were trade secrets, but your argument is that Suncoast didn't use them, and regardless there were no damages.
Respectfully, I'm not sure that I would concede that they were trade secrets. They're arguably confidential, and I think even if they didn't support the trade secrets claim, could support other claims of unjust enrichment. I mean, certainly, I will not argue that a competitor is allowed to take, job or bid related information from a competitor and use it to pursue business. But there is no evidence that it was ever used. I mean, typically the argument would be, you took my information, my bid was $1,000, and then you bid $900 and you got the job. There's not an iota of evidence that supports any such theory. And the information was returned as the court ordered. And again, there was never any linkage of specific damages related to the misappropriation or the use.
Thank you, counsel.
Anything?
We
Thank you.
appreciate your argument.
Thank you, sir.
Counsel, rebuttal?
Certainly, Your Honor. I'll touch on the recruitment issue first with respect to Mr. Robinson. I mean, it's pretty rare you see this level of evidence with respect to a solicitation claim. I mean, Mr. Robinson literally said he was recruited, he wasn't looking for a job, and that he was happy at Power Steel. And Mr. Walsh literally gave him a job offer and secured him a job at Suncoast while he was still working at Power Steel. It's very difficult to believe in any light, let alone on summary judgment in the light most favorable to plaintiff, how that does not amount to encouragement for Mr. Robinson to leave Power Steel. I think that with respect to the trade secrets issue, I think what counsel said was very telling and very illuminating. I don't think it's seriously contested that the documents with respect to the Toscana project, the pricing sheets, the estimate reports, the shop drawings were Power Steel trade secrets. There's no argument that Power Steel gave Mr. Walsh permission to give those documents to Suncoast. And with respect to the other jobs that estimate reports were found on Suncoast server, Mr. Walsh admitted that he brought all of his estimate reports with him to Suncoast, or he provided them all to Suncoast. And we had 7 estimate reports, again, not seriously contested that they're trade secrets, found on Suncoast server. And 4 of which, during the time before the TRO was entered in January, during the time between when Mr. Walsh had taken his job with Suncoast and between when he left Power Steel, 4 of those jobs were bid on that Suncoast was subsequently found to have Power Steel's estimate reports for, and they won 3 of those jobs. And I will say I think that Suncoast brief is maybe a little misleading on this, but there's no evidence that during that time Power Steel was not also a competitor and was not still bidding on jobs in January of 2019 before Walsh left. When an employee admits that he's taken these estimate reports, provide them to a competitor, they're subsequently found on the competitor server, and the competitor won the jobs, I think it's very reasonable in summary judgment to assume, to infer that competitor used those trade secret documents to win those jobs. And that's all we had to show at summary judgment, that they used them to win jobs. And we know the value of those jobs, we know their profit margin. For me, the trade secrets are very straightforward. With respect to Toscana, Walsh himself testified that he provided them to Suncoast to analyze the project. That's the use. He's testifying that he intended Suncoast to use the documents. And I want to step back, even if we don't get to unjust enrichment, I haven't discussed it much here, but there is the issue of reasonable royalty. And I think that the case with then Judge Gorsuch, I think kind of points out why the Trade Secret Act is structured as it is, kind of with 3 tiers of damages, right? It starts with lost profits, then it goes to unjust enrichments, and then reasonable royalty. And the point is that taking someone's trade secret always harms them, and the law is going to make them, I think what Judge Gorsuch says is that has its cost. They're going to make some sort of payment.
Your time is up, counsel. I'll let you conclude briefly if you choose to.
Certainly. I think in conclusion, Your Honor, we just think that it's warranted to reverse the judgment with respect to Suncoast and the entry of sanctions as to Suncoast and Mr. Walsh, and remand back to the trial court for trial. Thank you.
Thank you, counsel.
Thank you.
Thank both counsel for their arguments today. We appreciate them. We will take this matter under advisement and will issue a decision in due course. We stand adjourned.